Imagine this. You run a business, let's say in California. You've never been to New York, never done a deal there. Then, out of the blue, a legal notice shows up. You are being sued in a federal court in New York City. How is that even possible? Well, today we're going to unravel the mystery of the long arm of federal law and how it can literally reach across the entire country.
So, our story starts with a company called Hallwood Realty Partners, based in New York, and they've got a big problem. They're watching their company shares get snatched up, and they've got this sinking feeling that it's not just a friendly investment. No, they think a secret, hostile takeover is brewing.
So who are the alleged plotters? Hallwood points the finger at a handful of investment firms. They claim these firms are secretly acting as a single group to orchestrate the whole thing. And here is the absolute key to our story. While some of these investors are local, one of them, Private Management Group, or PMG, is 3,000 miles away in California.
And that one little detail brings us to the fundamental question of this entire case. It really challenges how we think about state borders and legal power. I mean, can you actually be dragged into a courtroom across the entire country in a state where you've never even done business?
To figure that out, we've got to first understand the lawsuit itself. What exactly was Hallwood accusing this group of doing that was so wrong?
Okay, so Hallwood's case is built on a specific piece of federal law known as the Williams Act. The rule is actually pretty simple. If you and your buddies team up to buy more than 5% of a company's stock, you have to raise your hand and tell the world about it. Hallwood was saying, hey, this group secretly blew past that 5% line, and their plan is to take us over and sell us for parts, all without the required public disclosure.
So while the other investors geared up to fight about whether there was a secret plot, PMG, our California company, played a totally different card. Their argument wasn't about the takeover. It was about them not even being in the right courtroom.
Their lawyers filed what's called a motion to dismiss, and their argument was powerful. They basically told the judge, look, with all due respect, we're a California company. We have no real connection, no minimum contacts with the state of New York. You, this court, you have no power over us.
Okay, minimum contacts. What is that? What is this rule that PMG is leaning on so heavily? Let's take a quick look at the legal playbook that decides where you can and can't be sued.
This whole idea comes from a massive, game-changing Supreme Court case from 1945 called International Shoe, and it created what we now call the minimum contacts test. The core idea is simple but profound. For a state court to haul an out-of-state company into its courtroom, that company has to have some real, meaningful ties to that state. It all comes down to one word: fairness. But what's really fascinating here is that it wasn't always like this, not even close. You go back to the 1870s, and the rule was super rigid. It was all about physical presence. Someone literally had to find you within the state's borders and hand you the papers, like a game of tag. Then, for a while, there were these legal fictions, but it was International Shoe that gave us the modern, more flexible standard that we use today. So based on all that, PMG's argument seems like a total slam dunk, right? No contacts in New York, so case dismissed. Well, here comes the twist. Because everything we have just talked about applies to state courts, and this case, remember, is in federal court. That changes everything. You see, the Securities and Exchange Act, the exact law Hallwood was suing under, has this superpower baked into it. It's called nationwide service of process. And you could think of it like this. It's a legal fishing net that a federal court can cast across the entire country, pulling in a defendant from any state, no matter where they are. And this, right here, this is the absolute heart of the matter. The minimum contacts rule we've been talking about comes from the 14th Amendment, and it's all about protecting states from each other. It keeps a court in Florida from messing with a company that only does business in Alaska. But in federal court, under a federal law, we're talking about the Fifth Amendment, and the logic totally flips. The question is no longer, do you have ties to New York? The question becomes, do you have ties to the United States? And for a U.S. company, the answer to that is always going to be yes. So, imagine you're the judge here. You're staring at this massive legal question. What does fairness really mean in this context? Does it mean protecting a company from the hassle of being sued far from home? Or does it mean making sure the federal government can actually enforce its own national laws? What do you do? The answer from the court was swift, and it was clear. The judge denied PMG's motion. The case was staying right there in New York. That California state line was not going to be a legal shield. But the judge didn't just ignore the idea of fairness. Instead, he laid out his own test. First, he said the federal government's interest in policing its own stock markets is huge. Second, PMG isn't some foreign company. It's an American corporation that enjoys all the benefits of the American economy. And finally, and this is the kicker, he said,
Let's be real. In a world with jets and email and video calls, having to defend a lawsuit in New York might be an inconvenience, sure, but it's not some extraordinary burden that violates the Constitution.
So why does all this matter to you? Well, because this principle is the engine that allows the federal government to enforce some of its most important laws, the ones that protect our financial system, prevent monopolies, and so much more. It means that if you're involved in a scheme that crosses state lines, you can't just hide behind your home state's border and hope to escape accountability.
Which leaves us with a really big, fascinating question to chew on. As our economy gets more digital, more national, more interconnected every single day, are the physical lines we draw on a map becoming kind of meaningless when it comes to finding justice? This case seems to suggest that for some of our biggest legal fights, the answer is already yes.